I received your complaint or your, I guess, answer, if nothing else. Mr. McLaughlin's not here.
Before the courtroom even comes to order, today's case feels like a ticking time bomb. Picture this: a tenant claims he's been locked out of his home while his rent was fully paid. No eviction notice, no due process, just new locks, lost medication, and a landlord with a camera filming it all. Welcome to Judge Simpson's courtroom, where the law meets raw human struggle. This isn't a typical rent dispute. It's a confrontation between power and vulnerability, a tenant battling both eviction and illness, and a landlord whose explanations get more confusing with every sentence. Judge Simpson's no-nonsense tone slices through the excuses as the case spirals from simple lockout to a potential multi-thousand-dollar judgment. As you watch, ask yourself, what's fair when the balance of control is this uneven? And how far can a landlord go before crossing the line into illegality?
Are you still locked out?
Yes, sir.
Okay, so how long have you been locked out?
I've been locked out over a week. And
what date? Give me a date, do you know?
It was Saturday.
Saturday?
Yes.
The 20th?
Yes.
So, I mean, I see this here. The locks just got changed?
Yeah, he just changed the locks. He tried to offer me $400 to move out so that someone next door could move in. And I told him, no, I'm not doing that, And he kept trying to offer me money. The next he came in and before that, two individuals that stay in the same house I stay in at 4 a.m. in the morning tried to break into my room. And I told the police about it and everything. And next I told Mr. McLaughlin, and he told me, he said, so what do you want me to do about it? And it's like, as part of the rental agreement, there's no criminal activity supposed to be taking place like that, in this house, no trying to break into anyone else's property and stuff. And
all right, sir, have you talked to legal services at all?
I've been to legal aid. Yes, sir.
Okay. What did they say?
I have my case manager here from CMH with me. Is it okay?
Oh, okay. Hold on. So you're a CMH consumer?
Yes.
Okay. All right.
All I know is my medication, my heart medication, my seizure medication, my lung medication. I've been without it. And this guy won't let me get it. And I've been really sick.
This is where the emotional weight hits. Daniels isn't complaining about inconvenience. He's describing a health crisis. Denying access to essential medication crosses from civil misconduct to moral cruelty. Judge Simpson maintains composure, but the subtext is fury. The court exists to protect citizens from exactly this kind of power abuse. Every word Daniels says adds gravity. Heart medication, seizure medication, same clothes for a week. This isn't drama. It's evidence. The audience should realize that in housing law, negligence can be life-threatening. Would a $400 offer justify someone's right to lock out a paying tenant? The question practically answers itself.
And I've been wearing the same clothes and I feel horrible. My rent is paid for July and all that.
Pardon?
My rent is paid.
So, okay, hold on a second. So your rent, you paid your rent for July and got locked out on July 20th?
Yes.
All right. He's not here. I'm going to treat your complaint as a counter complaint for lockout.
Yes, sir.
Okay, so there can be some serious consequences for him in terms of a money judgment if he has locked you out of the premises and doesn't sort of answer this claim here, but he's not here right now. So I'm going to adjourn this out 1 week, give him an opportunity to show up.
Okay.
And if not, then I'll figure out exactly what I'm going to do.
So what-
Typically, just so that you know, and you're telling me it's from the 20th. That was the day that the locks were changed. It's on the 20th.
Yes, sir.
Okay. So
I left out with a friend to go get something to eat because I had no food.
5,
And when I came
6,
back, he's standing there
7,
with the
8.
locks changed, and he's got a camera at the back door. I'm like, "What are you doing? Open the door." And he's like, "No. How much money you want, Daryl? I'll give you $400."
Visualize that moment. Daniel's returning home, groceries in hand, only to find his landlord filming him instead of unlocking the door. The sheer audacity of it amplifies the tension. Recording the confrontation may have been meant as evidence, but it exposes intent, control, not communication. Judge Simpson's silence here is powerful. He knows such footage, if entered into evidence, could strengthen Daniel's claim. In landlord-tenant disputes, optics matter. This clip would look less like property management and more like harassment. Viewers, think about it. How would you react if someone filmed you being locked out of your own home? Calmly doubtful.
I'm like, "Listen, man, I don't want anything. Give me back in my place. What are you doing?" And I was really upset, So I'm standing with groceries that I just got from, with a friend, and they wouldn't open up the door. And he's standing there just filming me, laughing,
All right. Okay. So just so that you know, under the lockout statute, it's typically $200 a day minimum that he may owe you.
Yes.
So I'm not saying that's what I'm ruling, and I'm not saying that that's what I'm doing. I'm just letting you know that because of what you filed. So I'm going to put it out to the second at 12 p.m. Give him an opportunity to show. If he doesn't show, then likely what's going to happen is, well, I'll have to figure out something to do because I want you to get back into your place.
Okay, but Your Honor, at this time, I have no place to go. I've been out on the streets, and I haven't been able to change clothes or nothing, and I've just been enduring this. And I'm right here with my case manager, and I don't know what to do.
No, I hear you, Mr. Daniels. There's not a whole lot that I can do. I mean, I could give you a judgment right now, but that doesn't help your situation right now. Okay. Yeah. I'll do it this way also. Not only will we send him a notice, I'm going to issue an order to show cause on this thing.
On the 21st. It's my position he relinquished on the 20th. I normally would have changed them on the 20th, but my son was in town and I didn't have time. I wanted to spend time with my son.
Excuses meet reality. I didn't have time. That line lands poorly in a courtroom. Judge Simpson's body language says it all. Family visits don't override statutory duties. Property ownership comes with legal obligations, not convenience clauses. This exchange shows why documentation matters. The landlord's timeline doesn't match the tenant's testimony, and every inconsistency erodes credibility. In legal settings, poor record keeping often does more damage than the original act. Question for viewers: when someone starts explaining with "I didn't have time," do you hear an excuse or an admission?
You're saying he relinquished it on the 20th, when he receives his alleged $400 from Mr. Temple?
Yes, on my behalf. Mr. Temple fronted the money. I reimbursed Mr. Temple the next morning.
I see this, but this doesn't even make any sense to me, Mr. McLaughlin. I'll be honest with you. How much was his monthly rent?
$510.
So where's the 400 come from? Where's that number come from?
Okay, he, on the 20th, he left me a voicemail saying he wanted to move out that day on the 20th, as long as he got his security deposit back. I responded that his security deposit at that time was down to $245, that I kick in some of my own money, making it even $400. And he accepted that.
Not to complicate things further, Your Honor, but Mr. Daniels does deny.
Denies what?
He denies that that's his phone number. The text and the calls allegedly sent to that number.
I have a phone number.
Go, sir. I just,
That's the phone number. I received a voicemail from him saying he wanted to move out that day, as long as he got his security deposit back. That's the previous exhibit.
Exhibit 2. Explain that to me. What you're saying there.
Basically, what this says is he started out with a $765 security deposit. He only made a partial payment on his June rent and no payments on his July rent. So by July 20th, when he said he wanted to move out, he only had $245 left on his security deposit, and I agreed to bump it up to $400.
So how is his security deposit being deducted before he's vacated? That was a question.
The $245 was arrived at by how much he didn't pay. The $765 is how much he didn't pay for his June rent and a prorated $17.
He hasn't vacated the premises. How are you deducting from his security deposit?
This is where the legal fireworks start. Judge Simpson dissects the landlord's math like a surgeon. The Security Deposit Act is clear. Funds remain the tenant's property until lawful deductions after vacancy and inspection. Deducting rent mid-tenancy is not just premature. It's unlawful. His tone sharpens. That's the tenant's money you are holding. It's both education and reprimand. In that moment, Simpson isn't just judging. He's teaching property law to everyone in earshot. Every true crime viewer loves a twist. Here, the twist is bureaucratic. The villain isn't violence. It's paperwork weaponized.
That number I arrived at
Not my question.
is assuming he paid.
Listen, Mr. McLaughlin, to my question. He has a security deposit. He hasn't, as of the time I'm looking at this calculation, vacated the premises. How are you deducting from his security deposit?
On a prorated daily basis. I don't understand your question, I guess.
Okay, that's because you don't understand the Security Deposit Act. How are you deducting from his security deposit? That's the tenant's money that you are holding. You do understand that.
Yeah.
So how are you deducting from his security deposit prior to his vacating the premises?
Yeah, I still don't understand the question. That would be the deduction, how much? I understand, $765 was his money. But then he.
So how are you taking it before he's vacated the premises?
I guess I can't answer the question.
Oh, no, I think you can answer it. I don't think you like your answer. Because I think you know you can't. So, Mr. McLaughlin, you've been in this court enough. If this were your agreement, which I understand Mr. Daniels is denying, why wouldn't you have just waited 5 days, come to court, stated the agreement, and then resolved it that way? If indeed this was the agreement.
This single question exposes the flaw in the landlord's defense. Why rush to change locks days before a scheduled court date? If everything was above board, waiting would have proved legitimacy. Impatience here looks like guilt. Simpson frames it perfectly. That would have been an option too. Calm, factual, but devastating. The landlord admits, maybe I should have done that. That's courtroom code for I messed up. Viewers, this is the turning point, the legal equivalent of a confession. The narrative shifts from dispute to accountability.
That would have been an option too. And in retrospect, maybe I should have done that, but he told me he wanted to move out that day on the 20th. And I wanted to honor what he wanted to do.
Okay. Is there somebody living in the premises now?
In the other rooms, yeah.
Well, let me ask this. So he's just not on the premises, right?
Right.
Everything else is the same as before he left.
Mhm.
His stuff is still in his room.
And we have an agreement that he can come get it anytime he wants.
This makes no sense to me. None. I'm not a handwriting expert, but I'm also. You have a copy in front of you of your exhibit 5. You're telling the court that's Mr. Daniel's signature?
Me?
Let me, hold on. Were you there when he signed it?
Absolutely.
Put him under oath, Mr.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help
Yes.
you God? State your name.
Pat McLaughlin.
Put Mr. Daniels under oath.
Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Daryl Daniels. I mean, when he signed this, he was standing up. So maybe that's.
Okay, and so what's that mean?
That means it might be illegible, but he did sign it.
Which copy? You have the agreement in front of you, a copy of the agreement that's signed?
Yeah, I agree they're different.
Oh, they're not just different. Those aren't by the same person.
Oh, yes, they are.
Oh, no, they're not.
I have 2 other witnesses who can come here and tell.
All right, then we're gonna have a hearing. You're gonna bring them in here. Everybody's gonna be put under oath, because I'm gonna tell you something, Mr. McLaughlin. This makes no sense whatsoever. That you are headed to court. You file an action, I think on July 8th. You are headed to court. 5 days before that, somebody, or maybe even before that point in time, somebody gives $400, then gives another $400. The stuff isn't moved out of the unit and the locks are changed. Outside of that, there is then this bizarre deduction from a tenant's security deposit, which apparently has occurred prior to him vacating the premises.
No,
Yes.
it's simultaneous with when he vacated.
No, but you're deducting before then.
No, but the money isn't exchanging hands until he's vacated.
Okay. So here's what we're gonna do. You're gonna find me a date that we can do this. When are these other people gonna be available? These witnesses?
John Mattis is available any day. Frank Temple is available any day except Friday. Well, Friday he's available, but he works later.
Well, I'll tell you what, I'm just gonna set it and then you gotta make sure they're here. Cause I mean, I'm not gonna work around everybody's schedule. Because it's gonna be your. And I'm gonna suggest to you, Mr. McLaughlin, based on what I'm looking at, you might want to get an attorney. Because for each day he's locked out of those premises, that by statute under the lockout statute is $200 a day.
Here comes the hammer. Simpson lays out the financial reckoning, $200 per day, attorney's fees, incidental housing costs. He's not calculating hypotheticals. He's setting the stage for restitution. The audience can feel the tension spike. The landlord's face likely tightens as the numbers stack. This is justice quantified, the law translating harm into dollars. What's striking is Simpson's restraint. No yelling, no theatrics, just math and statute. But behind the calm tone is authority, the kind that rebuilds fairness one line at a time. Would this penalty change how some landlords treat tenants if they knew it applied automatically?
That you would owe him. if I find that there's been an illegal lockout. Outside of that, because now he also has counsel, you could be liable for his attorney fees. Now, granted, one might say, so we can just skip over this argument, that since Mr. Henry is from legal services, that and he hasn't paid anything, you wouldn't be liable for any attorney fees. Not the way that works. He gets paid at the rate that an attorney in private practice would get paid, and that's what you would owe. If it's found that you violated that statute. So as I count it, right now, if it turns out, absent the other statutes that certainly council's aware of that could apply to this, just on the lockout, you're at $2,800 right at this point. And that doesn't include the
August 6th at 9 a.m.
I'll set a hearing. That'd be enough time for you to get counsel if you want to get a counsel, Mr. McLaughlin?
I didn't hear the date.
August 6th, Tuesday.
It's Tuesday? Yeah.
This upcoming Tuesday,
9 o'clock, that's fine.
August 6th,
Your Honor,
2024, 9 a.m. Yes.
if I may, would Mr. Daniels be allowed back in the premises until then? He has been being housed by community mental health, which I do have the receipts for here.
Well, yeah. Oh, that reminds me of something. Because I was informed that he was being housed by others. That is an incidental damage also, so that any housing expenses they have would also be included and are not part of that 28. But go ahead, Mr. Henry. I'm sorry, I didn't mean to interrupt.
No worries. In addition to that, I believe we have someone from community mental health here. I believe they aren't able to house him further than today.
No.
I'll let him in. I have no problem.
When is he gonna get the keys so that we're done?
Right now.
You got them with you?
I do, but I have to check which one fits the front door, so I'd have to go back. I could meet him there.
Okay. Why don't we do it this way? Because I just don't have a good feeling. Why don't you go get the key that fits, come back with the key so that I can watch it being exchanged and given to Mr. Daniels.
Sure.
So I guess technically I'll pass the matter until. Because I put in the account system yesterday, I don't have all the court filings, but I'd be able to get a copy of all that.
That's out of my home.
We can address that.
Sir,
Yes, sir.
sir, I'm not assuming, I am assuming nothing at this point. Mr. Henry, we will take care of you on that. Okay, thank you.
Thank you, Your Honor.
You're welcome. And Mr. Henry, when Mr. McLaughlin gets back, don't do any exchange until it's in here.
I'll be in front of you.
I want to see it myself because I don't want anybody, don't want to have to believe anybody else's lying eyes. Court calls.
And there it is, the judge's closing words. I want to see it myself, a declaration of integrity. In a courtroom full of confusion, Simpson stands as the last line of verification. No assumptions, no shortcuts. This case captures why housing law matters. The right to shelter is tied to dignity. And when landlords cut corners, the justice system steps in. The outcome isn't just about rent. It's about accountability, empathy, and the cost of carelessness. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments. And don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Behind the scenes, detectives were piecing together a timeline so tight that even the smallest inconsistency could expose everything. And this moment, it was the first real slip.